part of India, will continue to be a part of India. But the bogies today in the country a wrong narrative that Jammu and Kashmir is not part of India because of 370. That's not so. As Jawaharlal Nehru also not refuted when K.M. Shah said that yes, plebiscite. He said nothing doing. It's part and parcel of India. It's integral part of India. Unit of federal and the union legislature will get jurisdiction to enact laws on matters specified either in instrument of accession or by later addition with concurrence of government of state. And steps have to be taken for purpose of convening a constituent assembly in due course, which will go into matters I have referred. When it has come to a decision on the matters, it will make a recommendation to President who will either abrogate 3068 or direct that it shall apply with such modification exceptions or recommend. That, sir, is briefly description and effect of this article. I hope the House will carry it. And House carried it. Today's House has no moral or constitutional authority to undo this just because it has a majority. For the people of Jammu and Kashmir, this was the essential feature of the Constitution. And we said, why forget this? We could bring Jammu and Kashmir into our fold. In fact, during this assembly debate, Maulana Hassan said, you are discriminating in favor of Jammu and Kashmir. Because Baroda Maharaja, and I come from Baroda, I didn't know this story at all, but it is mentioned here. Baroda Maharaja also didn't want to join the union. I didn't know that. And he was physically brought from England and forced to sign. So Maulana Hassan says in this debate that you have forced Baroda Maharaja to sign it. He didn't want to sign it.
CJI Rao.
CJI Rao. I was shocked to read because CJI Rao is perhaps the greatest of the rulers of 20th century. I don't know whether your lordship knows or not, but the man was absolutely unbelievable. I have been telling family to have a biopic on him. Because he was the one who sent Dr. Ambedkar for education. He was the one who always took guidance from Maharishi Aurobindo, who stayed in Baroda for many years. And some of the greatest people. Girl child education he made compulsory in 1920s. Girl child education, free and compulsory. And I was telling Dr. Dhawan in the morning that I saw a law against water pollution which was drafted in 1920s. The man had a vision which was the University of Baroda, if your lordships have seen, so beautifully designed on Oxford-Cambridge lines. So, and a Maharaja would not take a penny more than what was decided for him by his Diwan at the beginning of the year. That you have to only spend this much for your personal expense, he won't touch a penny after that. But he therefore didn't want to. Now just see, my learned friend wants me to read, but at page 1177 perhaps, or 1178. Now it is not case. Which page? 1177 last para.
In fact, 1178, see that one para which says, now you will recall.
Yes. That in some of the clauses of this article, we have provided concurrence of government of state feel that in view of commitments already entered into between state and center, they cannot be regarded as final authorities for giving this concurrence, though they are prepared to give it in the interim period. But if they do give this concurrence, this clause provides that concurrence should be placed before Constituent Assembly when it needs, because it was not a transitional governments.
So therefore, the concurrence of the government also, in terms of the first proviso to clause D, was still the Constituent Assembly was convened and took a decision under clause 2. So even Mr. Iyengar construed it in a way that this concurrence was only up to that point when the Constituent Assembly would come into being.
No, Lord, that may perhaps.
What he says, that they will give that in the interim periods till the Constituent Assembly is formed, after which that power is exhausted itself.
Text of clause 2, just see in the context of 1.
So in which case, really speaking, there's no question of concurrence by the state government after 1957.
No.
But yet we operated that provision.
Please see that on C and D at page 1177. Clauses C and D refer. Your Lordship, see. Clauses C and D refer to provisions of Constitution. My Lords have it.
Yes.
Clauses C and D refer to the provisions of the Constitution other than matters listed in List 1 and 3. These various provisions have been divided in certain categories. First, according to this draft, is Article 1 of the Constitution will automatically apply. As you know, it describes territory of India and includes amongst territories all states mentioned in Part 3. J&K is one of the states mentioned in Part 3. With regard to other provisions of the Constitution, these will apply to Jammu and Kashmir state with such exceptions and modification as may be decided on when President issues order to that effect. That order can be issued in regard to subjects mentioned in instrument of accession only after consultation of government of state. In other matters, concurrence of that government has to be taken. What your Lordship's read was in Part 2 because the government was an interim government. So, whether that government was rightly giving rightly giving advice or concurring. So they said, let people decide to that limited extent. Now, next para. Now it is not the case, nor it is the intention of members of Kashmir government whom I took opportunity of consulting before this draft was finalized. It is not their intention that other provisions of Constitution are not to apply. Their particular point of view is that these provisions should apply only in cases where they can suitably apply, when only subjects with modifications and exceptions as particular conditions of J&K state may require. I wish to say no more about particular point at the present. So that is how he looked at it. That is how he defined. There is no other interpretation possible. This is the author. And one of the most respected, eminent citizens of this country. What on 5th of August, President issues a proclamation. Then it is sent to Rajya Sabha. Rajya Sabha sends a recommendation without on the same day. Then Rajya Sabha approves reorganization bill on the same day. Next day it goes to Lok Sabha on the same day it is approved. But these Constituent Assembly debate took place over several years. These are the men and women who are most brilliant that have ever been born in this country. We owe a permanent gratitude to them. And if we were to interpret Constitution as today's governments tell us, we will be doing great disservice to these men and women. Please don't do that, Lord. They were much wiser than anybody in our generations. They knew what India's problems were. As Dr. Dhawan was at pains to point out, they knew about the diversity of this country. They felt the pain of every part of this country. And that pain they brought in various provisions to recognize this. It's not the article is not just a letter. It's the feelings of people of Jammu and Kashmir.
What next, Mr.
Yes.
Davina?
Now, Lord, kindly come to, in this context, the two judgments which I respectfully submit are squarely supports the view that I have. Lord, kindly turn to PDF volume 1, isn't it? At page 8, Premnath Court. It's 1950.
Volume 1 of the case.
October 25, 1947.
Volume, sir.
Which page?
Swetanbhai, volume 1, page 7. Case law compilation.
Para 10. Your Lordships may turn to para 10. Lordships have got it? On October 25, 1947, Maharaja signed an instrument of accession with India, which had then become an independent dominion. By first clause of instrument, the Maharaja declared that he had acceded to dominion of India with intent that Governor General of India, Dominion, Legislature and Federal Court and any other dominion authority established for purpose of dominion shall, by virtue of instrument of accession, subject always to the terms thereof and for the purposes only of dominion, exercise in relation to state of Jammu and Kashmir such functions as may be vested in them by or under Government of India Act and so on. So we may usefully refer to some of the other clauses of instrument. Then Lordships may omit all that. And please kindly, thus, last sentence of that para. Thus, by the instrument of accession, Maharaja took the very important step of recognizing the fact that his state was a part of dominion of India. So this is very important, my lord. The repeal does not subserve any purpose. Jammu and Kashmir is integral part of India. Now kindly turn to my lord. Lord, please turn to paragraph. There is one more argument. Page 287. I haven't written. PDF page 15. Para 26. No, where is para? Page 16. Para 26. There is one more. No, just before that. Lord, just before the paragraph 26. Please see last sentence of para 25. We must therefore reject the argument that the execution of instrument of accession of para 26 last sentence. I'm sorry. Why are you confusing? I asked you to write this down and be carefully yesterday. Last part of para 26. We must therefore reject the argument that the execution of instrument of accession affected in any manner the legislative, executive and judicial powers in regard to government of state of which then vested in ruler of the state. So for all purposes, your Lordship's court recognized that not he was the state who wielded all the powers. And his instrument of accession didn't take away those powers. Although he became part of India. Now see, my lord, next paragraph. There is one more argument which has been heard before us on the question of Maharaja Hari Singh's powers. It said that Maharaja issued proclamation on March 5, 1948, replacing emergency administration by a popular interim government headed by Sheikh Abdullah, constituting council of ministers who were to function as cabinet and act on principle of joint responsibility. He virtually introduced a popular democratic government in state, surrendered his sovereign rights and became constitutional monarch. There is no substance in this argument. The proclamation merely shows under pressure of public opinion and as a result of difficult and delicate problem raised by tribal raid, Maharaja very wisely chose to entrust actual administration government to charge of popular cabinet. Then Lordships may omit all that and please kindly come to Lord page. Since Mr. Chatterjee has relied, page para 32, page 18. Since Mr. Chatterjee has strongly relied on application of Article 370 of the Constitution to the state in support of his argument that Yuvraj has ceased to hold plenary legislative powers, it's necessary to examine provisions of this article and their effect. But these two judgments are a complete answer to what has happened. And these judgments bind your Lordships. There is no reason to differ from this view. This article was intended to make temporary provisions with respect to state of Jammu and Kashmir, then so and so. Now, Lord, please see after the article, Lord, clause 1B of this article deals with legislative power of parliament to make laws for the state, and it prescribes limitations in that behalf. Under para 1, subclause B, clause 1, parliament has power to make laws for state in respect of matters in union list and concurrent list, which president in consultation with government of state declares to correspond to matters specified in instrument of accession. Whereas in regard to other matters in the state list, Parliament may by under para 2 have power to legislate for the state after such other matters have been specified by his order by President with the concurrence of the government of the state. It is significant that para 1 refers to consultation with government of state while para 2 requires concurrence. Having thus provided for consultation with and concurrence of government of state, the explanation shows that government of state means in this what it means in this context. It means, according to appellant, not the Maharaja acting in his himself in his own discretion, but person who is recognized as Maharaja by President acting on advice of Council of Ministers for this. It is said on this explanation that appellant has placed great reliance. Subclauses C, D, and 1 of Article provide respectively provisions of Article 1 and the present article shall apply in relation to the state, and that the other provisions of the Constitution shall apply in relation to it, subject to exceptions and modifications specified by presidential orders. These provisions are likewise made subject to consultation with or concurrence of government of state respectively. Having provided for legislative power of Parliament and for application of articles of Constitution to the state, Article 372 prescribes that if concurrence of government of state required by relevant clauses has been given before Constituent Assembly of Kashmir has been convened, such concurrence shall be placed before such assembly. For such decision it may take. This clause shows this, what your lordships are rightly worried about. This clause shows that constitutional makers attach great importance to the final decision of the Constituent Assembly and continuance of exercise of powers conferred on the Parliament and President by very relevant temporary provisions of 371 is made conditional on the final approval by said Constituent Assembly in said matters. So what 371 continues with that. Once more it continues, then 373 becomes OTOs. He authorizes President to declare public notifications that this article shall cease to be operative or shall be operative only with specified exceptions or modifications. But this power can be exercised by President only if Constituent Assembly of State makes recommendations in that behalf. Thus, proviso to clause 3 also emphasizes importance which was attached to final decision of Constituent Assembly in regard to relevant matters covered by 370. Please turn to next para on the same page on the said construction, para 38. Please omit first 10 lines or 5 lines. 5 lines. The constitution makers were obviously anxious. My lords have that? Para 38, yes. 4th or 5th line. The constitutional makers were obviously anxious that the said relationship should be finally determined by the Constituent Assembly of the state itself, not by Indian Parliament. State itself. And that is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. It would not be permissible or legitimate to hold that by implication this article sought to impose limitations on plenary legislative powers of Maharaja. These powers had been recognized, specifically provided by the Constitution Act of the state. It was not and could not have been within contemplation of competence of constitutional makers to impinge even indirectly on the said powers. So from Maharaja they got transferred to Constituent Assembly, those powers. So they say that you can't impinge on those powers. It would be recalled that by instrument of accession, these powers have been expressly recognized and preserved, and neither subsequent proclamation by Yuvraj Karan Singh adopting as far as applicable the proposed constitution, nor constitutional order subsequently issued by President purported to impose any limitation on said legislative powers of the ruler. Please see this. These decisions, I have completely answered long back. What form of government the state should adopt was a matter which had to be and naturally left to be decided by Constituent Assembly of the state. Until the Constituent Assembly reached its decision in that behalf. Now see these words. Until the Constitution Assembly reached its decision in that behalf, the constitutional relationship between the state and India continued to be governed basically by instrument of accession. It would therefore be unreasonable to assume that application of 370 could have affected or was intended to affect plenary powers of Maharaja in matter of governance. In our opinion, appellant's contention based on this article is therefore rejected. Now, Lord, please turn to this para because this is a little important. It is difficult to see how this article purports. Para 40. Para 40, but not after 12 lines. The word starting with the constitutional position. 12 lines. How many? PDF 21.
Altogether issue whether the Yuvraj would have really issued the
Sampath Prakash now.
Sampath Prakash.
Same volume. It starts at page 27 at 30. 27 at 30. The earlier page at 29, but at 30, please see the answer. Learned counsel urged In this background, Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed.
You are reading paragraph?
Learning files, okay.
Page 30, para 4. Para 4.
Just the paragraph above para 5.
Yes. Learned counsel urged that this background Article 370 of the Constitution could only have been intended to remain effective until Constitution of the state was framed and the will of the people of J&K had been expressed, and thereafter this article must be held to have become ineffective, so that modifications made by President in exercise of powers under this article subsequent to enforcement of Constitution of state would be without any authority of law. Now please see the answer to that. Next paragraph. We are not impressed by either of these two arguments advanced by Mr. Ramamurthy. So far as historical background is concerned, Attorney General appearing on behalf of government also relied to urge that provisions of Article 370 should be held to be continuing in force. Please see that note. Mr. Daftari. Should be held to be continuing in force because situation that existed when this article was incorporated had not materially altered, and purpose of introducing this article was to empower President to exercise discretion in applying Indian Constitution. There is considerable force in this submission. Legislative history of this article cannot in these circumstances be of any assistance. That this article became ineffective after Constituent Assembly of the state had framed the Constitution.
Yeah.
It is again.
Completely against you, Mr. Dave.
Please see that. There are, however, much stronger reasons for holding previous.
Even para 5, it says should be held to be continuing in force.
Yes.
And then 6,
7, in fact, 6 and 7.
6 says that the second submission based on 2 of Article 370 does not find support even from the language of that clause, which only refers to the concurrence given by the government of the state before the Constituent Assembly
Just a
Assembly,
second.
and makes
The
no
second
mention at all of the completion of the work of the
Does
Constituent
not
Assembly.
find support even from language of that clause, which only refers to concurrence given by government before the Constituent Assembly was. That's what I'm submitting. No, that's a very limited. It's a
this-
temporary provision within a temporary provision.
But this seems to give seems to hold that the article in its entirety would continue to govern even after the Constituent Assembly had completed its task.
No, not as a whole.
Read 7.
Just para 7.
Let me read it, no. Your Lordship may allow me to complete.
Yes.
There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after Constituent Assembly of State had passed Constitution. The most important provision in this connection is contained in clause 3 of article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications, and from such date as President may by public notification provided recommendation of Constituent Assembly of State referred to in clause 2 shall be necessary before President issues. This clause clearly envisages that article will continue to be operative and can cease to be operative only if, on the recommendation of Constituent Assembly of the state, President makes a direction to that effect. In fact, no such recommendation was made by Constituent Assembly of the state, nor was order made by President declaring article shall cease to be operative. On the contrary, that's important. It appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in the article was notified by the President by Ministerial Law Order dated 15 November 52 and laid down that from 17 November article was to be operative with substitution of new explanation for old explanation. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative, and in fact expressed its agreement to the continued operation of this article by making a recommendation it should be operative with modification only. Lord, it can't be, you can't now resort to 373 to repeal it. Constituent Assembly has accepted, it's a one-time exercise. President acted upon it.
It is not repealed, Mr.
No, it becomes inoperative.
So from time to time, this is what I said earlier, time to time COs have been issued.
No, we are not on 371. I am on 370 sub-article 3.
Even the present exercise, other argument being open, it is not removed. It has applied the other provision. As it exists in the statute of the constitution.
No, Lord, they have repealed it. They have deleted it. They have exercised 373 to delete it.
All
The way
provisions,
it is, I'll just tell you
now,
also.
now as it stands is, all provisions of this constitution amended from time to time when it will apply.
Yes, but they have abrogated 370 and applied all the provisions of the constitution. Both they have done. That part was not permissible. Now see further new.
So Dave,
Hmm.
we can just go a little earlier. Paragraph 4,
Yes,
first argument and the second argument, that will clarify the situation.
the-
It's at page number 29, 28 rather. The first argument
Yeah.
was that the
first
article,
argument was that this article contained temporary provision which ceased to be effective after Constituent Assembly convened for purpose of framing Constitution of J&K had completed its task by framing Constitution. Reliance was placed on historical background in 370 included so and so. Then Lordships may omit. The answer is Lord.
and then it goes also, as you have done,
Now the new one.
and in this background, then it's stated that background Article Code 370 could have been intended to remain effective till the constitution of the state was framed and the people of Jammu and Kashmir had been expressed, and thereafter must be ceased to have become ineffective so that modifications made by the president and
without authority. Now see the answer raised. I'm grateful to your Lordships. Your Lordship said no. But we are not on that. It's not our contention that 371 doesn't apply or president can't exercise powers under 370 sub-article 1. As not recorded in at page PDF page 31 para 7. That's the answer. That it was not left to the Constitutional Assembly, otherwise it makes mockery of the provision. If now somebody else, complete stranger, were to decide, the governor will make a recommendation, or the president will make a recommendation, or parliament will resolve. Here what they have done is that parliament resolved. That's an unusual procedure. It's neither a constituent power nor a legislative power that parliament exercised on 5th and 6th of August 2019. Parliament resolves that president may issue an order under 373, abrogating it. It's an extraordinary, I must say, legislative act, parliamentary act. It's neither legislative nor constitutional. It's not a constituent power.
Reading right.
Advice that because state is under president's rule, parliament therefore is constituent assembly or legislative assembly, and therefore this could be done. But it can't be, because that has come to an end. Not speaking for Federal Court, Chief Justice Kanya said this in 1949 FCR. Jatindranath Gupta versus Bihar, Lordships are aware of that judgment. As a general rule, and unless it contains some special provision to the contrary, after a temporary statute has expired, no proceedings can be taken upon it as it ceases to have any further effect. 373 is that. 1949 FCR 595. It's at volume 30, not page 18. I'm not going to trouble reading it. But this is a state, and this has been recognized subsequently. Even General Clauses Act doesn't apply. Your Lordship said to temporary statutes. And Article 367 expressly begins with a non-obstant clause subject to the contrary. Article 367 begins with a non-obstant clause, says subject to the contrary, unless context otherwise requires. Now, Lord, 370, therefore, context is completely different.
Does apply. Section 21 will apply that what you said.
I am looking to the statute and making submission on, because the federal court judgment was not granted. I'm sure you will get opportunity.
No, this judgment says that the General Clauses Act will apply it.
Yes, I have seen that. Lord. I have seen that. I have marked that portion also. But Lord, my respectful submission is that here, because of the context of 373, I respectfully submit that in respect of sub-article 3, there is no question that it should apply. Now, my Lord, one judgment that I would like to place before your Lordships for consideration is, my Lord, so my Lord, this is my second argument that my Lord 370, my Lord, sub-article 3 stood exhausted, and therefore President my Lord neither could exercise powers nor could Parliament recommend to the President to exercise that power. Just to look at the counter affidavit which has been filed on behalf of Union of India. Lord, common counter on all, it says, Lord, it's a counter which is for all, a comprehensive counter, they call it. PDF file, common counter.
This will be in the paper book, right?
Yes.
501.7.
Oh, 501.7.
Thank you, Mr. Gordon.
501.7.
Mr. Courtmaster, kindly.
Page UDA?
2990.
2990.
Which is the internal page. Yeah, you're on the right side. So the way?
Lord, Lordships may kindly turn to page 13. Do your Lordships have page 13?
It will be 3104.
Sub-para 7. 7. 7 or 8? What is it? 8. As has been explained in greater detail.
Just one second.
Para
Five.
16, Mr. Mehta.
3005.
At page 13.
Para 7.
Page 3005.
PDF
Can you turn to para 7?
PDF 3005.
As has been explained in greater detail in later paragraphs of this affidavit, it was observed over years. Existing regime under Article 370 and exemptions modifications carried out to the provisions of Constitution of India by presidential orders issued under 371D were impeding rather than enabling, facilitating full integration of erstwhile state of Jammu and Kashmir with rest of the country, which was neither in national interest nor in interest of state of Jammu and Kashmir. How impeding? Somebody makes a statement from Home Ministry, giving no detail as to how it has impeded. Law and order problem certainly exists, but it is not because of applicability or otherwise of the Constitution. Now, please turn over, Lord, kindly turn to paragraph, straight away to paragraph, Lord, page 18. Page 18. Part of para 8, no? Roman 5. Lordship said that? Page 20 perhaps, PDF page 20.
Mr. Dave, are you inviting the court to review the wisdom of the decision of the government on the abrogation of 370? So you're saying that judicial review should reassess the basis of the government's decision that it was not in the national interest to continue with Article 370.
Chief Justice Chandrachud said in A.K. Roy that not this theory that was developed in United States Supreme Court that political decisions courts shouldn't go into. That is now brought. That was given and in Podial, your lordships expressly rejected that argument.
But judicial review would be confined to a constitutional violation. Constitutional violation, certainly it's amenable to judicial review.
Lord, I would respectfully submit that even subject.
There's no doubt that if there's a constitutional violation, this court has a jurisdiction to review. Of course, that's undoubted.
Let me put it this way. President is undoubtedly exercising powers under 370, purportedly. In Samsher Singh, your lordships have said that president can only exercise presidential power in constitutional sense. No other sense, not personal.
But the wisdom underlying the decision to abrogate.
There is no question of wisdom. President can only look at 370. President has to be advised by his advisors that 373 does not exist today.
Then we are back therefore to the constitutional argument. Constitutional argument, of course, judicial review was available, and we are addressing ourselves to that. There's no doubt about it.
Your lordships are right.
Fraud on the Constitution.
I am on fraud on Constitution that president is today exercising a power without any material whatsoever, without any justification whatsoever, and to wish it away by simply saying that it was impeding. But surely this court is not going to accept that kind of a very cavalier affidavit on part of Union of India. Yes. To say
370 would.
Argument was this, that these are political questions, don't go into it. Your lordship said nothing going, we will go into them. And now after Bomai, your lordships have expanded the horizon. Your lordships have gone to an extent. What I now just see two more things in this Lord affidavit. Kindly turn to Lord paragraph 15. It's a bundle of contradiction, their affidavit.
Paragraph 15?
Yes.
What PDF page will that be?
PDF 25. Oh, thank you, Mr. Copeland.
3015.
I state and submit that Constituent Assembly of erstwhile State of Jammu and Kashmir did not in any manner deviate. Please see that word. Did not in any manner deviate from provisions of Constitution of India, which would be applicable to erstwhile State of Jammu and Kashmir. Constitution of J&K adopted by this Constituent Assembly included Section 3, which unequivocally stated, State of Jammu and Kashmir is and shall be an integral part of Union of India. Additionally, Section 5 stated, executive and legislative power of state extends to all matters except those with respect to which Parliament has power to make laws for state under provisions of the Constitution of India. There can be no doubt that.
The way, do we really need to labor on the counter? We have to interpret the constitutional provision as it stands. How is this relevant?
Your lordships are right. I'm submitting that there are no reasons available in presidential exercise, nor are they given in counter. It's bereft of many reasons, the whole entire exercise.
Really.
That's my respectful submission.
Yes.
Now see last sentence. There can be no doubt, therefore, Jammu and Kashmir became integral part of India and Constituent Assembly, an elected body, had also given its imprimatur to the provisions of Constitution of India. Now, please see in this regard, two decisions. Kindly turn to the judgment of Lord. Not on fraud. Just see one paragraph of this judgment. But this is the Constitution, then judgment in Mudaliar on fraud on the Constitution. Just see these interpretations, and then I'll take to the next.
Where will we get it, Mr. Dave?
Volume 28, case law, volume 28, page 8, and relevant part at 15. 8 at 15.
Volume 28, case law compilation.
This leads. PDF page 19, I'm sorry.
19.
This leads us to the consideration.
Mudaliar is at internal page 7, right?
16.
Just see at page 19. Open PDF, then there is
8 at what para?
Para 16.
16.
16.
This leads us to the consideration of the question of scope of doctrine of fraud on power. In Gajpati Narayan, Justice Mukherjee, as he then was, explained the doctrine. It may be made clear that outset doctrine of colorable legislation does not involve any question of bona fides or mala fides. The whole doctrine resolves into a question of competency of a particular legislation. If legislature is competent to pass law, motives which impelled it are irrelevant. On the other hand, if legislature lacks competency, question of motive does not arise. Whether a statute is constitutional or not is thus always a question of power. Learned Judge describes how legislature may transgress the limits. Now, this is important. Such transgression may be patent, manifest, or direct, but it may also be disguised, covert, or indirect. And it is to this later class of cases that expression colorable legislation has been applied in certain judicial pronouncements. Now, in DC Vadva, your lordships go further, and that is at page. Parliamentary recommendation, in my respectful submission, suffers from complete colorable exercise of parliamentary powers. It was neither exercising constituent power under 368 nor any legislative power. Resolutions are passed by Parliament on many issues, sometimes not even to honor some individuals or to say some other things or to recognize great events in the country. So Parliament here passes resolution and says, Mr. President, you kindly do this. That, in my respectful submission, is a pure act outside parliamentary powers. And they did it only because the assembly was dissolved. purporting to act as assembly of JNK. We are now, since assembly is dissolved, therefore president has the powers and parliament therefore has powers under 356. Volume 19, my lord, page 118. Just one para. That one para. Lord, para 7, PDF page 131.
Which judgment is this?
Lord, this is DC Vadwa.
1 second. Page, PDF page?
Of volume 19, 118 at 131.
No, that's some other judgment.
The state of Tamil Nadu,
That's state of Tamil Nadu versus Padmavati Ammal.
volume 19,
19.
PDF 131, I think 131.
One.
You are referring to DC Vadwa?
Yes, my lord.
Yes, difference.
So we have some other judgment.
No,
Padmavati Ammal.
Yes, Padmavati. Volume 19.
Page, what is the PDF page number?
Oh, yes, it's 118 actually. It's immediately after that. It's 118.
9859.
Page 118 at 131.
131, para 7. Where does it begin?
State of Tamil Nadu.
हाँ नहीं उसके बाद में
No trouble, your lordships, reading that. The emergency power of the governor was not in the context of ordinances, but just above where Justice Mukherjee's dictum in Gajpati Narayan is cited, just above that,
At-
4 lines above that,
at page 133. Huh?
133. It is settled law. No, this is what I place for your lordship's kind consideration. It is settled law that a constitutional authority cannot do indirectly what is not permitted to directly. If there is a constitutional provision inhibiting the constitutional authority from doing an act, such provision cannot be
Yes.
allowed to be defeated by adoption of any subterfuge. That would clearly be a fraud on the constitutional provision. This is precisely what was pointed out by Justice Mukherjee. And that's my respectful submission that Lord and Lord Mudaliar is also considered. Now, Lord, last judgment that I placed for your lordship is the UP Assembly case, volume 30,
This was
PDF page 73.
33, page 1. Just
Volume 30, PDF 30, 73 at 92.
Volume?
38. Volume 30, my lord. Volume 30. So, Lord, this is the special reference.
PDF?
PDF 30. Sorry, PDF 73. Volume 30, PDF 73 at 92, para 38.
What's the name of the case?
That is that any powers, privileges and immunities of state, UP case.
What page are you referring to?
So, Lord, at para 38, 92.
92.
Page 92, para 38.
Dealing with this question.
Yes, ma'am. grateful. All your lordships have that, my Lord Justice Khanna?
Just give me a minute.
Yes.
Paragraph number?
38.
38, okay. Yes,
In
got it.
dealing with this question, it's necessary to bear in mind one fundamental feature of federal constitution. In England, parliament is sovereign, and in words of Dicey, the three distinguishing features of the principle of parliamentary sovereignty are that parliament has right to make or unmake any law whatever, that no person or body is recognized by law of England is having a right to override or set aside legislation of parliament, and that right or power of parliament extends to every part of Queen's dominion. On the other end, essential characteristic of federalism is distribution of limited executive, legislative and judicial authority among bodies which are coordinate with independent of each other. Supremacy of constitution is a fundamental to existence of a federal state in order to prevent either the legislature of federal unit or those of the member states from destroying or impairing that delicate balance of power. That's precisely what has happened, destroyed the delicate balance of power, which satisfies the particular requirements of states which are desirous of union, but not prepared to merge their individuality in unity. You can't rewrite history, and a constitutional history can certainly be never rewritten. That's why it's durability. This supremacy of constitution is protected by the authority of an independent judicial body, your lordships. Independent judicial body to act as interpreter of a scheme of distribution of powers, nor is any change possible in the constitution by the ordinary process of federal or state legislation. Ordinary process 370, president issues, parliament pass resolution.
Yes, Mr. Ray.
Thus, the dominant characteristic of British constitution cannot be claimed by a federal constitution like ours. Then what next paragraph? Our legislature have undoubtedly plenary powers, but these powers are controlled by basic concepts of the written constitution itself and can be exercised within legislative fields allotted to their jurisdiction by 3 lists under the 7th schedule. But beyond the list, legislature cannot travel. They can no doubt exercise their plenary legislative authority and discharge their legislative functions by virtue of powers conferred on them by relevant provisions of the constitution. But the basis of power is constitution itself.
Yes, Mr. Davi, we read that. Thank you. Which is the next judgment, Mr. Davi?
Pull out one sentence, pull out in
Yes.
paragraph 40, last sentence, PDF page 93. Therefore, there can be no doubt that the sovereignty which can be claimed by Parliament in England cannot be claimed by any legislature in India in the literal absolute sense.
Yes.
But whichever way one looks at it, but your lordships may look at the UP Assembly case, or your lordships may look at Samshed Singh's case. If not, the exercise of power by the constitution or by the parliament has to be done under the constitution itself and in the constitutional sense, then in my respectful submission, not constitutional sense or constitutional provisions prohibited both the president and parliament from not touching Article 370, sub-article 3 in any manner to abrogate it. There is no power to abrogate Note 370 under 373 because Lord, as I respectfully submitted, that Lord, it has lived its purpose, its object, and therefore it no longer is Lord available for exercise. In any case, the exercise Lord suffers from a fraud on the constitution because Lord, it has been done completely contrary to constitutional provision. And Lord, the principle of federalism, principle of democracy, which Lord Bombay has so beautifully Lord ascribed. Because ultimately, that's why Lord constitution